Hello, this is John Milburn for Laws 11059 Statutory Interpretation, and we're now dealing with Week 6 material, which relates to intrinsic materials, the statute components. All right, so what does all that mean? So this week we're dealing with issues around what's involved in the statute, what's comprised of it. The best way to deal with this is to look at a couple of resources. The first is a statute itself. Choose any one. For example, the Mental Health Act 2016, I think, is a good example in Queensland. Then consider how legislation comes into existence. I've already referred you to the Queensland Legislation Handbook. Just a reminder how valuable a resource this is. I'll share the screen, and hopefully now you see that on your own screens. This is the contents page, and you'll see that part 1 deals with the context of legislation. Now, why am I showing you this and why is it relevant? Last week, you'll recall that I said that in order to properly interpret legislation, the High Court has provided us with guidance. We need, amongst other things, to consider the intent of Parliament. And one of the ways that we deal with that is to look at the way in which the intent of Parliament is determined by courts and also by legislative drafters. Well, the Queensland Legislation Handbook is really designed for legislative drafters. So if you need to follow their rules and apply them in statutory interpretation, and I would suggest you do, then have a look at the handbook. Number one, what is the context of legislation? How does it fit within the scheme of things? It talks about jurisdiction, which is one of the first elements that we talked about in the process of interpreting legislation. That goes to the issue of identification phase, which is jurisdiction. And then when in the context of external materials or extrinsic materials, we've talked about looking at policy, why the bill, the Act was introduced, what are the mischiefs that it seeks to remedy. So looking at policy issues is important. Then, of course, we've considered the issue of the drafting of the bill in the context of the committee system, the first reading, the second reading, ultimately preparing it as legislation, and the importance of the parliamentary process. Now, in Queensland, explanatory notes is important, and you'll see that I've highlighted that on a number of occasions, and then finally, royal assent. Now, there are some fundamental legislative principles that you need to understand and be ready to apply. A lot of these go back to common law canons and common law principles. So, for example, if you're interpreting legislation and you believe that it may not be consistent with principles of natural justice, then in this instance, section 7.2.2 would be relevant. Legislation must be consistent with principles of natural justice, for example. And there are other provisions in that handbook that equally apply here. So, for example, it's increasingly becoming the case that legislation allows for the delegation of administrative powers, which is delegated legislation, and also increasingly the case that on occasion at least, there is a reversal of the onus of proof in criminal proceedings, and that can only be done where there's adequate justification for doing so. So to supplement the material that you have in your textbook, I'd urge you to consider this material because it's a source material actually used by those who draft legislation. And in my view, it's important that you consider it. So there are some excellent resources available for you when it comes to determining how the material within a statute actually got there in the first place. Now, when we're looking at the exploration phase, to look at that which is described by Sanson in her flowchart, and if you're not with me, clearly that's the flowchart I'm referring to, then you need to consider context and purpose. I know we've talked about this before. So we know that we do know, of course, as a general principle, that if you're reading the domestic violence legislation or the Mental Health Act, or you're reading the Environment Protection and Biodiversity Conservation Act at a Commonwealth level, whatever it is, you can't simply read the words of a section of an act and apply them without looking at the words of the surrounding sections and indeed the entire act. Now, if you want a case as authority for that proposition, have a look at K&S Lake City Freighters Proprietary Limited against Gordon and Gotch. It's a High Court decision, 1985, 218 CLR, Commonwealth Law Reports 216. Now, of course, it's fine if you have time or the resources and the financial backing to consider that type of statement in the context of litigation in the High Court. But for many lawyers, as we discussed last week, and by reference to subsection 3 of 15 AB, we need to consider the statement within the context of resources and the length of time it will take. So when I talk about having the ability and the requirement to read the Act within all of that context, we've got to take into account in a practical sense the time it takes to do that. Now, last week we talked about leading or dominant provisions as opposed to subordinate provisions. By now, I expect that you've looked at Project Blue Sky against the Australian Broadcasting Authority in that regard. All right, so today we're dealing with intrinsic materials and the components of the statute. So where do we start to look? Well, the long title is always a good place to start. Traditionally, legislation includes both a long title, which is at the commencement of the Act, to identify the object or purpose of the legislation. So it's a great source to look at initially. Or then there's the short title. And the idea of a short title is to save time for ease of reference. Now, short titles may be used in interpretation. However, generally, their brevity means that they may have little interpretive value. That's not always the case. Indeed, sometimes the short title provides even more benefit to interpretive value than the long title. For example, in the textbook, Sanson, there's reference to the Tax Laws Amendment, Temporary Flood and Cyclone Reconstruction Levy Act 2011. Now, that's the short title, and it tells you quite a bit. But the long title is simply stated as being an act to amend the law relating to taxation and for related purposes. It tells you a lot less, doesn't it? So sometimes you need to look at both the long title and the short title. Sometimes the long title, you can say, deals with the issue of purpose of legislation, and the short title sometimes deal with the issue of intent. Both important, but for different reasons. Please look at both. Now, there might be a question going through your mind as to what do we mean by some of these terms? So, for example, often I've referred to statutory purpose, and often I've referred to statutory intention. Now, they're not the same thing. And this is where you need to catalogue this sort of material and bring it into an answer at the appropriate time. I'll give you an example. So if our purpose was to reach the airport, we may intend to achieve that purpose by, for example, taking a taxi or a train or a bus or a combination of those things, or we could get a lift with someone. That is, the statutory purpose focuses on the why and the who. The statutory intention focuses on the what and the how. This is really important. You've got to get your head around this. Statutory purpose is dealing with why and who. Statutory intention, what and how. If our purpose was to reach the airport, we may intend to achieve that by what and how. I hope that makes sense. So purpose looks at the why the legislation is needed and who towards to whom it's directed, and the intention is concerned with what is done to meet the purpose and how it should be implemented. Another thing that you might consider is the preamble. Preambles set the scene. We don't see them often now in modern legislation. They were very common in older parcels of legislation. So they're introductory statements. And if you like, the idea of a preamble is to set the scene, to provide the appropriate background and the motivation behind the document. That's what the preamble is all about. They're often used in constitutions and very formal pieces of legislation. They're very common still in international treaties and resolutions of United Nations bodies. They're no longer widely used. They're quite unusual in domestic legislation. So I guess in a way you could say that preambles relate to that which was, but also that which is, but in a higher level than what we're normally dealing with in terms of domestic legislation, international treaties, constitutions, etc. So the idea of a preamble was not initially used in the interpretation of the statute unless there was some ambiguity, because courts didn't view the preamble as part of the Act itself. If we go back to what we discussed in week 1 or 2, the Act's Interpretation Act tells us what is part of the Act and what's not part of the Act. So keep that in mind as well. But all of this has changed with the modern approach to interpretation. So for example, in the Commonwealth sphere, have a look at section 13(2)(b), which does provide that a preamble is now part of the Act. So that's the Act's Interpretation Act Commonwealth. Realistically, when you're looking to determine the object of legislation, where would you look? Well, in most pieces of legislation, helpfully, have an objects clause. So that is vitally important in almost every instance where you need to interpret a piece of legislation. You need to look at the objects clause because it provides communication as to the true purpose of the legislation, and objects clauses are very commonly included in legislation in modern drafting. Go back to the Queensland Legislation Handbook and you'll see how legislative drafters introduced objects clause, how and why they're introduced. So objects clauses generally appear in an Act and they may and should be used in interpretation. But it's not always exhaustive. So you may consider whether the objects are apparent from the whole of the Act or the way in which the objects were intended to be furthered by the legislation. And indeed, a court can go further by referring to extrinsic materials in identifying the purpose to supplement the intrinsic guidance provided by an objects clause. Therefore, you're perfectly entitled to go beyond the objects clause and look at materials such as the second reading speech, the explanatory note accompanying a bill to determine the object or the purpose of legislation. So don't restrict your research necessarily to objects clauses. Now, by now, you should know how to access explanatory notes, second reading speeches. If you don't, you need to stop and catalogue that material and have it readily accessible, because you'll need to introduce that in answering questions. Now, another very important part of the text itself, a very common statutory component, is definition sections, but there's a trick. It's a trick to definition sections. Now, it's very common for Acts to have a definition section. Sometimes they're a little hard to find, sort of, because they're not actually part of the Act. They're very often part of a schedule. Not necessarily Schedule 1, there might be Schedule 4, 3 or 4, or whatever it might be. Sometimes the definition is in part of the Act. And sometimes, and this is the tricky bit, there may be different definition sections that apply to different parts of the Act. So you'll commonly see in a chapter or a division or a part, there may be a definitions section that relates to that chapter or to that part, or as the case may be. So keep an eye out for that and don't necessarily assume that a definition remains constant throughout a piece of legislation. It should, but it doesn't always. So there's an example, for example, sometimes the definition sections are included at the beginning of individual parts of lengthy legislation. So an example is this, it's in your text. Section 44AB of the Competition and Consumer Act 2010, it deals with just some part of the legislation, not the entire part. So therefore, take care to go beyond a definition section of general effect to consider the part of the legislation under consideration. So the dual mistakes might be to introduce something that's general, which has been essentially overridden by a specific piece of legislation, or to take that specific and make it general when it should only apply to a particular part of the legislation. I do hope that makes sense. Now, a definition is an explanation of a word or phrase. It's designed to assist in interpretation. However, the High Court decision of Kelly against the Crown, 2004-218 Commonwealth Law Reports at 216, says it's not a substantive legislative provision. Now, that may only be a term of art, but still keep that in mind. Now, last week, we spoke about the words that are exhaustive or not exhaustive. For example, some words, and this is the eugistive generis rule, generis rule. Some are exhaustive, some are non-exhaustive. So the basic principle applies for statutory interpretation. And there are some words that are used as triggers here. So if you see the word means, then it should apply all that it refers to. Another word that's often used is includes, which of course means that this is some, but not necessarily all. So where the statute says means something, that's intended to be exhaustive or a complete definition, but where a statute says includes, by reference to a list of things, they're merely examples. They don't limit the definition from including other things. So when it comes to the general principles of statutory interpretation, now we're looking at the statute components themselves. And we need to consider the type of construction that's used. And you'll see this word often, construction. Consider that within the context of interpretation. Generally the same sort of thing. When we talk about a statutory construction, we're talking about what does it mean. So the construction of the words must be considered within that context of all of the words that are used. Have a look at, for example, the Civil Liability Act, Section 12, which provides for an award of damages in certain circumstances. And it gives you an idea of the sort of wording that's used by legislation, the creators of legislation, generally. But when you read a section like that, apart from reading it within context, always be prepared to go back to the Acts Interpretation Act. So, for example, Section 14 says material that is and is not part of an act. It talks about material that is and isn't part of the act. 14A talks about the interpretation that will best achieve the purpose of the act, is that which is preferred. And 14B talks about the use of extrinsic materials. 14D has some examples, or talks about the use of examples rather. So look at that. Also, this is going back a few weeks, remember, for example, Section 32CA, which talks about the difference between may and must. And 38, which talks about commonly used words and meanings. So, but sometimes you may have to go beyond the act itself to work out the meaning of different words. And usually people will go to the Oxford Dictionary. If not, it's Oxford. If not Oxford, maybe Macquarie. So the inquiry is determined by reference to a number of sources in that regard. Now, when you're talking about the statutory components, then consider the headings and the use of the word, the headings, how they work. Then the schedules, I've already mentioned that in the context of definitions. Notes, are often very important as well, because they provide some expansion upon the material, and also consider punctuation, examples, and penalties. All right, but all of that is within the term of context and the background. Remember that when legislation is drafted, it's drafted against an existing body of law. It's made in the context of other legislation or common law, which is judge-made law. It's also made within the context of the Constitution. Now, all of these matters go towards assisting in determining its true meaning within the context of the legislation. So we have to consider the reference to context always. And the reason I'm stressing this again is that this week we're dealing with statute components, and it's easy to fall into the trap of considering those statute components in isolation, which we can't do. I've mentioned a range of sources, including, for example, the Constitution, that is relevant in that regard. So the Constitution is not to be treated as an ordinary statute. I put it in a special category earlier in this session because it does have an overriding importance, but it's still a statute that does need to be interpreted as well. Always consider the purpose, and it's unnecessary to justify purposive construction of legislation that is mandated now by statute, and refer to the Acts Interpretation Act, Project Blue Sky, for example, in that regard. And remember that when legislation is created, it's, as I said, it's not in a vacuum, and quite often, as we saw earlier, by reference to rules relating to natural justice, legislation must be considered within the context of it respecting fundamental rights and human rights. So when legislation is prepared, there is an overriding, if you like, assumption that it's created consistent with human rights. Now, that's particularly relevant in the current regime with the introduction of the Human Rights Act, which relates to the Charter of Human Rights and Responsibilities at an international level. So whenever you're considering statutes, in addition to reading the statute components, read them within that broader context. All right, we'll wrap up now, as we have recently, with a series of questions. As you probably gathered, these questions relate to last week's work. So if you're ready, a few more questions for you to answer. Question 1. Intention in statutory interpretation involves A, looking at what was said in Parliament when the bill was passed into law to see what the intention of parliamentarians present at the time was. B, use of a fiction whereby what Parliament meant is determined through examination of the statutory words it has used. And C, both of the above. Question 2. Which of the following statements is correct in relation to applying the concept of intention to legislation which predated Mabo? A, there is no way Parliament could have intended to extinguish native title through the passing of legislation if native title had not even been recognised at the time. B, it doesn't matter that Parliament had no actual intention. All that you need to do is look at the rights granted by the legislation and see if they are inconsistent with native title, and C, both of the statements are correct. 3, reading down is used where a court A considers the statute to be constitutionally invalid, B reads out the relevant parts of the statute in court in order from the beginning, or C constrains the meaning of words used. Question. Straining, this is question 4, straining is used where a court A stretches the meaning of the words used beyond their ordinary meaning, B sifts out irrelevant parts of the statute in order to carefully examine the relevant provisions, C considers what a state legislature has enacted, considers that a state legislature has enacted legislation which is more correctly within the power of the Commonwealth. 5, reading in involves A, a court applying the definition section from NAC to the specific provisions where the definition words were used. B, a court using extrinsic materials to better understand the meaning of a statutory provision. C, Parliament holding a session in which newly presented bills are read for the first time. And D, a court reading a provision as if it contained additional material. All right, that'll do us for this session. Keep up the good work and we'll see you in class. Thank you.